Hi, welcome to the what is the 8th in a series of webinars which are being put on by Farrar's building. They've been running through the course of the lockdown period as an opportunity for us to stay in touch with those who instruct us, an opportunity for us to share learning. The webinars are then stored on the Farrar's website. So if you go to the Farrar's website, you can see that there's a number of interesting talks which have already been delivered and can then be accessed over the internet. And this talk will also be available on that facility as well. The talk is about traumatic birth injuries, which, as people will imagine, is a relatively big and relatively complex subject in the context of clinical negligence and personal injury work. As a result of that, what I'm going to try and do is give an overview of the topic, something that people can listen to and get a broad understanding of the subject. Obviously, with any topic of this level of complexity, there are going to be subtleties that perhaps we won't get to address. But there is a question and answer facility available. I think that if you scroll down on the webinar, and some people may have used this facility before, you're able to put a question in it under the Q&A logo. And what will happen then is at the end of the webinar, if there's time, I'll deal with any questions that come through. They come through anonymously, so that there'll be no names mentioned, and any questions that I'm able to address at that time, I will. If we haven't got the time to do that, or if I'm not able to answer questions that come through for complexity or whatever reason that might be, my details are on the slides. I'm very happy that people email me directly at Chambers with any queries that they may have, or pick up the phone, and I'll try and help in any way that I can. I can't promise to know the answer, but I can certainly promise to try and assist. I'm Andrew Aronson. I'm a clinical negligence and personal injury barrister at Farrar's. My work is in the personal injury field, is largely to do with serious catastrophic injuries and the consequences that flow from that. And then I deal with a range of clinical negligence work, both for claimants and for defendant trusts as well. So that's my background in terms of coming to these traumatic birth injuries. As one perhaps will understand, the complexities of the subject are perhaps obvious. The complexities of the subject obviously come from the fact that the birthing process itself is something where decisions are made in very, very short split-second contexts, and where the difference in time periods, the difference in delays can have major catastrophic results. When one does cases of this sort, the timelines in terms of what happened when, we're talking about delays of minutes, and on those minutes, major consequences can flow. Obviously, you've also got a situation where there are a variety of different clinicians involved. And each will bring their different training, their different skills, their different standards of work. And that crossover of disciplines through the liability process presents problems for us as lawyers, both in terms of looking at breach of duty and in terms of looking at causative consequences. The second element that may again seem very obvious is where you've got a significantly injured child with care needs and accommodation needs and all of those treatment needs for the rest of their life, then inevitably in terms of quantum, it's going to be a complicated case involving a range of different experts, both medical and non-medical. It's usually going to involve issues of a professional deputy with because the claimant won't have capacity, and obviously a structured settlement in terms of a PPO. So all those factors which make any high value personal injury claim complicated are particularly complicated in cases of this sort. The final and perhaps underestimated element that presents a challenge to us as lawyers in these type of cases is the emotional strain. These are cases which often go on for a long period of time, and in which the lawyers become almost personally involved. You try and keep, obviously, a personal and professional perspective on things, but it's very difficult not to become emotionally involved. Now, for claimants lawyers, that might seem an obvious statement. This is a case where a badly injured child needs compensation, and the costs and the consequences of that are readily apparent to anyone. It's a very humbling process if you actually represent a child and you go to visit them in their home, where you see how the family are adapting to their disability, and you see the way that siblings are assisting, the way that the parents are dealing with it. And it's for somebody who doesn't necessarily come to work every day with an emotional hat and necessary, these are the type of cases that it really would have, you'd have to have a heart of stone not to be pulled in and involved in that way. But just to turn it on its head, I do these type of cases for defendants as well, and there's an emotional element to that, because you have professionals who have specialized in an area of medicine that involves the care of or the birth of children, and for many it's a vocation as much as a profession, and they're very, very driven in their desire to provide the best level of care, and very often justifiably opinionated in terms of the way that things should be done. So when you have a situation where things have gone wrong in that process, whether or not they accept there are errors, but the fact that it's gone wrong has such significant consequence, it's very difficult for them to understand that. It's very difficult necessarily for them to engage in that process. And again, that provides an obligation on us as lawyers to explain the process in a way that I don't have that same difficulty with more general clinical negligence cases. These type of cases involve having to explain to defendant trusts or individuals involved in the same, with the same care and the same emotional involvement that you'd have to explain things to claimants and claimants' advisors and family when you represent the claimant. And that seems to me to be an unusual feature and pretty specific to these type of cases. Now, just starting with some basic definitions of placental abruption is when the placenta peels away from the inner wall of the uterus, either partially or completely, and that has the effect of depriving the baby of oxygen and nutrients. Hypoxia means an insufficient supply of oxygen. Hypoxia ischemia means an insufficient supply of oxygen to an organ by reason of an inadequate blood flow. Hypoperfusion is what occurs when there's an insufficient blood flow to the organ, but reperfusion then means the restoration of blood flow to that organ. And a reperfusion injury is a common aspect of these claims, means the restoration means it's an injury that's caused when there's hypoperfusion, and reperfusion causes a surge of blood to the organ, which causes damage. Now, the ventricles are the interconnected cavities within the brain where the cerebrospinal fluid is produced. An intraventricular hemorrhage is a hemorrhage within the ventricle, and again, a very common source of brain injuries of this type. Now, a placental abruption before birth can cause hypoxia ischemia, leading to a reperfusion injury after birth in the form of an IVH. Bradycardia is when the heart is beating too slowly. Normally, if the fetal heart rate goes below 120 beats per minute, it's considered to be bradycardia. And uterine rupture is obviously an injury to the wall of the uterus. The risks of that occurring in an ordinary birth are something like 1 in 12,000, but the risks where you have somebody who has previously had a cesarean section, and the VBAC means a vaginal birth after cesarean section, the risks of a uterine rupture increase from the 1 in 12,000 up to about 1 in 280. So although it's a small risk, it's a very much, it's an increased risk, a very considerably increased risk as a result of having a vaginal birth after a cesarean section. Now, I don't apologise for going back to basics in relation to the standard of care. Obviously, the appropriate test is the Bolam test. You can't do a clinical negligence case. You can't read a clinical negligence judgment without there being reference to Bolam. The standard of care is that of an ordinary competent medical practitioner. A medical practitioner is not guilty of negligence if they have acted in accordance with a practice accepted as proper by a responsible body of medical persons, simply because there's another body who would take a contrary view. And to that extent, it's a very difficult case for a claimant to satisfy. It's still remarkably common that you get an expert who may give, on the face of it, supportive evidence on the basis that they wouldn't have considered doing what was done at the time. But if you then have a responsible body of medical opinion who can be identified who would have taken a contrary view, then the test is obviously not established. Now, the standard of care is to be judged by the standard of knowledge available at that time. That becomes increasingly important in cases of this type, because you're frequently looking back 20 years as to what happened at the time of a claimant's birth, and it's important that the standards are applied are the standards as existed then, because obviously medical science progresses over time. And again, sometimes that's lost in the preparation, certainly, of preliminary reports. If a defendant doctor specialises in some particular area of practice, then of course they must be judged by reference to the ordinary standard of that particular practice. So if you have an obstetrician or a neonatologist, they are judged by the standard of the ordinary obstetrician or ordinary neonatologist. So far, so conventional. Now, I flagged up in the slides FB. The relevance of that is that there are certain medical skills that are absolute, that a doctor either has or doesn't have, and the standard is equivalent. Now, in that particular case, it was a situation where an A&E senior house officer had taken the history, and they hadn't asked the questions that it was accepted that the more senior consultant would have asked in the same situation. And the issue was, well, whether they had their standard of record keeping was a breach of the standard to be applied in relation to an A&E senior house officer. And what was said by the court is that the history taking is a basic skill that all medical professionals should have, and there was no difference between the standard of that as between an A&E house officer and a consultant. Each was expected to do it to a requisite and to the requisite standard. Now, often in clinical negligence cases, you have a situation where there's been a failure to diagnose and treat. And in those circumstances, the but-for test on causation requires an inquiry into what would have happened if treatment had been provided. And in Bolitho, what happened was that there was a failure for a doctor to attend and to treat a claimant. And it was accepted that had the doctor intubated the claimant, that the claimant would have survived. However, the doctor's evidence was that even if she'd attended, she wouldn't have intubated, and that the result wouldn't have been any different from what occurred. And it was argued that that decision not to intubate was a reasonable decision supported by a reasonable body of clinicians, and therefore not a breach of duty. Now, a judge in those circumstances has two issues to decide. The first is a factual issue. Well, what would that doctor have done had they attended in time? And then the court proceeds to consider, well, was that treatment, the treatment that the doctor says that they would have administered, was that negligent? Was a body, is there a body of respectable clinicians who would have done the same thing? Now, provided the treatment contended for by the defendant was with the sort of treatment that was accepted as responsible or reasonable by a responsible body of clinicians, then that is the approach that the court takes. And in that particular case, causation wasn't made out. Now, there's another important part of the Bolitho judgment which has to be considered, which is the approach that's adopted in terms of a conflict in expert evidence. It's often been referred to as the Bolitho prism, in a sense, how the court looks at expert evidence. Now, what's said in that case is that in making an assessment of experts' evidence, the court should always take into account a variety of factors, including, but not limited to, whether the evidence is tendered in good faith, whether the expert is responsible, competent, respectable, and whether the opinion is reasonable and logical. So just because the defendant calls an expert who says that they would support a different form of treatment doesn't per se mean that the Boland test is defeated and that the claimant doesn't win. What the court has to consider is, does that view withstand logical scrutiny? Now, it's explained in a cancer case, a recent cancer case in 2019, Mrs. Justice Yip, the case of Dalton. Now, what happened in that case, just to understand the background, is that the claimant went to her GP in 2011 with a lump on her breast. She was aged 38 at the time and was then referred to the defendant's specialist breast clinic at the Southmead Hospital. The lump was estimated by the GP to be something in the region of 2 to 3 centimetres. Now, the claimant was seen by a consultant breast surgeon. Following clinical examination, ultrasound and a mammogram, the claimant was informed that the lump was a benign fibrocystic change. No biopsy of the lump took place. In fact, it subsequently transpired that the claimant had a small cancerous tumour in that part of the breast, which was only 3 millimetres in diameter, and it wasn't detectable either through mammography or through ultrasound. Now, about 2 years later, in 2013, the claimant attended her GP after noticing changes in the lump. She was referred or re-referred to the breast clinic, and a large grade 2 ductal carcinoma was diagnosed. Now, despite the delay in the diagnosis, the claimant responded well to the treatment, which was obviously a slightly more invasive type than otherwise would have been the case. But in fact, by the date of the trial, the claimant was determined to have been cured, which is obviously thankful for those that aspect. A quantum between the parties was agreed in the sum of about £145,000. But the essence of the dispute then was between the respective experts. The claimant's expert considered that in the absence of a clear radiological appearance of a cyst, the lump should have had a core biopsy, which he contended would have identified the tumour back in 2011. The defendant's expert took a different view. The prevailing guidelines in terms of what to do were an algorithm, and one went through the steps, and one would only proceed to a core biopsy if there were suspicions of malignancy in either the clinical or the radiological findings. So the claimant's case was that in the absence of clear evidence that it was benign, a biopsy should have taken place. The defendant's evidence is in the absence of clear evidence that it was malignant, there was no requirement to biopsy. And the defendant's expert said that the biopsy would have been blind, although the lump was 2 to 3 centimeters. The cancerous tumor was a small part of that, only 3 millimeters. So it was unlikely that the core biopsy would have identified the tumor. Now, Mrs. Justice Yip then proceeded to apply the Bolam test through the prism of the test set out in Bolitho. A doctor's not negligent if they act in accordance with the views of a responsible body of medical opinion, even if another body of opinion would have acted in a different way. So the fact that the defendant called a distinguished expert who would not have proceeded to a core biopsy demonstrated on its face that the defendant's surgeon had acted in accordance with a responsible body of medical opinion, because obviously the defendant's expert was saying that. It was only then if the court could be satisfied that the opinion of the defendant's expert did not withstand logical analysis, it did not withstand logical scrutiny, and in some way ought to be rejected, the finding in favour of the claimant could be made. In fact, interestingly, in that case, the claimant's expert actually accepted that on a literal interpretation of the guidelines, the core biopsy wasn't required. So there was no substance to the suggestion that the defendant's expert, or indeed the defendant's breast surgeon, had been negligent. The learned judge then proceeded to find that whilst it was possible that the biopsy could have identified the lump, it was not more probable than not. And so the claimant failed to establish either breach of duty or causation of injury. The case is interesting in terms of how the court looks at a conflict of expert evidence, where on the face of it, the defendant has evidence which suggests that what was done fell within the body of a reasonable body of clinicians. Now, Montgomery, again, I don't apologise for going back to basics. Obviously, Montgomery in 2015 very much changed the law, and around about that time we were all inundated with articles and I'm not sure whether webinars were quite so common in those days, but certainly we were all inundated with articles in relation to the changes. What happened is that the Supreme Court distinguished between cases of alleged negligence by a doctor in diagnosis or treatment and cases of negligence in respect of advising the patient on the risks which treatment may entail and the alternative treatments which are available. Now, traditionally, both of those tests were addressed by considering the responsible body of medical opinion. However, in relation to the latter test now, the duty is to take reasonable care to ensure that prior to treatment, the patient was aware of any material risks and any reasonable alternative to the proposed treatment. It's the court then that assesses what would have been reasonable for the doctor to say, and the court can then bypass some of the problems that have been faced in terms of applying the Bolam test. Now, Montgomery obviously was a birth case. The child sustained severe injuries at the time of birth. Mrs. Montgomery was diabetic. She was small in stature. There was a risk, therefore, that the baby would have large shoulders and have difficulty passing through the mother's pelvis without medical intervention. There was evidence that if the risk materialised, it could give rise to a major obstetric emergency. Now, in antenatal consultations, Mrs. Montgomery expressed concerns about the size of the baby, but she did not seek specific advice about this, and the doctor did not volunteer such information because in the judgment of the doctor, the risk to the baby was very small, and if it was mentioned to the mother, a mother would elect caesarean section, and that was not in her best interest. So it was the doctor withholding information because the doctor considered that what was being done was in the best interest of the patient. That was a decision that a responsible body of clinicians at that time would have adopted. So the doctor advised that the mother would manage vaginal delivery, and if there were difficulties, then a caesarean section could be given. Now, in the event, what happened was that the risk of shoulder dystocia materialized, so the baby was caught as a result of the anterior, the forward shoulder. The emergency then obviously developed very quickly. It didn't permit a cesarean section to take place, and the baby suffered injury in the course of delivery using forceps. Now, the appeal before the Supreme Court concerned allegations that Mrs. Montgomery ought to have been given advice about the risks of shoulder dystocia, which would arise in vaginal birth, and then of the alternative possibility of delivery by elective cesarean. Now, the claimant failed in the lower courts by the application of a case called Sidaway, in which the House of Lords had provided for a uniform approach based on the Bolam test. But the Supreme Court declined to follow that decision, indicating that the time had come to review the appropriate test. And that it was preferable to have an approach which reflected the fact that patients were adults who were capable of understanding the medical treatment, that it's uncertain of success, it may involve risks, there is a responsibility for accepting certain forms of treatment, but patients, given the requisite information, were entitled to make those decisions themselves. So there's a basic distinction between the doctor's role in providing first diagnosis or treatment, and secondly then when advising about risks or alternative treatment. In respect of the first, the doctor must follow the practice of the ordinary skilled members of the speciality, but in respect of the second, and then the quote is on the slides, so I won't read it out, but essentially it's giving the decision-making process to the patient, and the court then assessing what would have happened had that information been given, and had the patient been given the opportunity to make their own decision. Now, on the facts of this case, Mrs. Montgomery should have been informed of the risk of shoulder dystocia. The evidence suggested that had she been told that, she would have elected delivery of the baby by cesarean section, and of course the injuries that occurred during the birth process would not have occurred at all. Now, there are two exceptions in relation to Montgomery. The first is the doctor is entitled to withhold information when they reasonably consider that disclosure would be detrimental to the patient's health. The second is the defence of necessity, where there are circumstances where the patient requires treatment urgently, but is unconscious or otherwise unable to make a decision. Other than that, the obligation is upon the doctor to give the patient all of the information and allow them to make that informed decision. And that's been a very, very significant change in the way that cases are looked at, and indeed in the way that the medical practice has adapted to the change in obligations. Now, it's a distinction with a difference. It was an important case. It's very, very helpfully indicated or made clear in the case of Webster, which I say in my handout was a recent case. It was recent certainly when I initially wrote this this paper. But it was a 2017 case that went to the Court of Appeal. What happened is that the claimant was born on the 7th of January with profound physical and cognitive impairments by reason of a brain injury that occurred about 72 to 48 hours before birth. It was not disputed had the claimant been delivered by the 4th of January, and the claimant would have avoided the injury. There was an ultrasound scan which had taken place in November. The fetus was small, and there was asymmetry in the circumference of the head and the abdomen. The claimant's mother was under the care of a consultant obstetrician. Following the scan, the consultant did not note the abnormalities, and it was admitted that the consultant acted negligently in failing to arrange further scans based on that. Now, the mother was admitted to hospital on the 26th of December, feeling unwell. The next day, with the expected date of delivery, she'd assumed that the son would be delivered on that day. Now, her case was that hospital should have offered the possibility of an induction of labour on the 27th of December, which, if then accepted by her, would have meant that the claimant avoided the brain injury. The hospital argued that further ultrasound scans should have been undertaken, which would have provided reassurance. The anomalies that were on the scan would not have given rise to the need for heightened vigilance or advice about any dangers to be avoided by induction. Now, the judge found, as a matter of fact, that had the mother been advised that she would, of these things, she would have proceeded to induction. But that the consultant was acting in accordance with a responsible body of medical opinion in not altering the conservative course, so proceeding to a normal natural delivery. It couldn't be said that the view of that body was an irrational or illogical decision, and therefore the claimant failed. The matter then was appealed to the Court of Appeal, and what was said is that the approach had changed following the decision of Montgomery. It was no longer the Bolam approach. The doctor's obligation now in cases other than where it would damage the patient's welfare, was to present the material risks and to allow the claimant or allow the patient to make their own decision. The question then for the appeal court was what what conclusion the judge should have reached in terms of identifying what information the consultant should have presented to the mother and what the response would have been. The judge had found that the information should have included a list of anomalies and complications which could be avoided, which could not be avoided by early delivery, but also the increased risks of perinatal mortality based on a very small statistical base. And the consultant should have told the mother that there was an emerging but recent incomplete material showing risks of delay in labour in cases with a combination of the features that applied in that case. Now, if all of that information had been given to the claimant's mother, as a matter of fact, it was found that the claimant's mother would have elected to have induced labour on the 27th of December. And that conclusion was reached even if the advice given to the claimant's mother had been, there are these risks, but we think they're very small and we think you should proceed to natural birth. So even if it had been couched in favour of the conservative option, the evidence was that the claimant's mother would have elected to have an early delivery. And as a result of that, obviously, the injury to the claimant wouldn't have been sustained. And the Court of Appeal then reversed the trial judge's finding and found for the claimant. It just illustrated the difference because it was a case where initially it had been determined on the Bolam test as applied at that time because that was the law. When it was subsequently looked at on appeal, applying Montgomery, there was a completely different result. And the evolution of that concept, it can be found in the very recent case of AXA and the University Hospitals of Bristol. And this is a case where a 6-year-old boy, the damages were a lump sum payment just shy of £6 million, with periodical payments of about £160,000 from now, which I think we're going to increase to about £260,000 in about 10-15 years' time, as a result of the claimant suffering brain damage and brachial plexus injury during childbirth. The claimant was quadriplegic, cerebral palsy, required 24-hour care, suffered severe learning difficulties, incontinence, limited communication skills, and had a reduced life expectancy. So a very severe case of cerebral palsy causing a very common, unfortunately, very common sequence of consequences. Now, the claimant was the second child of his mother. His mother, when she previously given birth, had experienced problems with shoulder dystocia, but the midwifery staff at that time had not advised her of that problem. And what they had noted is that for any future delivery, matters should be flagged up with a community midwife for obstetric-led care. In fact, the claimant's mother did have obstetric-led care, but when the consultant obstetrician examined the claimant's mother prior to delivery, the consultant didn't have the notes and didn't have the history of the previous problems with shoulder dystocia. As a result, the claimant proceeded to an ordinary vaginal birth. Now, the claimant's case was that had the mother been told of the previous shoulder dystocia, had they been told of the potential risk of that recurring and the potential risk to the child if that took place, then the claimant's mother would have elected a caesarean and would have avoided, obviously, the birth process and avoided the injury. Again, it's on the basis of the issues of the claimant being given or the claimant's mother being given the requisite information in order to allow her to make her own choice. And after an initial dispute on liability was agreed, and the matter then only went to the court to determine the appropriate quantification of the claim. The defendant accepted that, but for the breach of duty, the claimant's mother would have elected to undergo a caesarean section, which, of course, on balance of probability, would have avoided the claimant suffering a hypoxic birth injury during the course of the natural birth. It's important, again, it illustrates that the obligation is on medical practitioners to give the patient the choice, to allow them to make an informed decision. And failures in that frequently lead to findings of liability because of the whole problem it would have been avoided had one proceeded to a caesarean section. Now, there are 4 liability examples that are up on the screen, just looking at time in terms of where we are. The first three are all cases where the claimant failed. And again, there's no science to this in terms of these are very difficult cases to prosecute, and perhaps any research done looking at cases will indicate that. The final case on the list is a case where the claimant was successful. So just looking at those in a little bit of detail. Bainham illustrates the huge difficulties with conflicting expert medical evidence. The claimant's mother was 28 weeks pregnant when she suffered pain in her stomach. She attended the defendant's hospital, where a midwife noted a fetal heart rate of 85 beats per minute, which is bradycardia. He diagnosed preterm labour and decided that an emergency caesarean section was required. In fact, the diagnosis was incorrect. The correct diagnosis was a placental abruption, and the need for caesarean section was even more urgent. And the resultant delay of 30 minutes before surgery actually took place was admitted by the defendant to be negligent. Claimant was safely delivered, but scans subsequently revealed a brain injury, and it became clear that the claimant had quadriplegic cerebral palsy and significant learning difficulties. Now, the matter proceeded to a 3-week trial. The claimant's case was that 25 to 30-minute delay had materially contributed to her disability. The defendant's case was that the claimant would have suffered precisely the same disability regardless of the delay in delivery. Now, the medical evidence confirmed that the claimant had suffered an IVH at some point between birth and the first cranial ultrasound a couple of days later. This was a reperfusion injury, so one has hyperperfusion when the blood is stopped, and a reperfusion when the blood then runs through. The hypoxic ischemic event was the placental abruption, insufficient oxygen and blood flow to the brain due to hypoperfusion. But then after she was born and prior to the ultrasound scan, these nutrients were restored and acted as a spark, starting a reperfusion injury, which accounted for the brain injury. The claimant's case was that there was a second pathology. The placental abruption caused hypoxia ischemia, which caused progressive increasing brain injury. The hypoxia ischemia during the period of negligent delay caused the claimant to suffer additional brain damage and then increase the severity of the reperfusion injury when it occurred after birth. So immediately one can see that the difficulties with that contention, that the claimant was always going to have a serious injury as a result of the placental abruption and the reperfusion injury after birth. But what was being said is that the 30-minute delay meant that the claimant would have did suffer a more serious injury than otherwise would have been the case. The defendant's case was that the placental abruption, followed by the loss of the fetal blood supply, made it inevitable that a reperfusion injury would occur after birth. That injury became inevitable well before the time when delivery should have occurred, the 30-minute delay. Mr. Justice Goss preferred the defendant's medical evidence. It was known and agreed that the claimant was compromised as a result of the abruption. As a result, she suffered a reperfusion injury after birth that couldn't have been avoided. That would cause a complicated high-grade brain injury, which in itself could account for the totality of the disability from which the claimant was suffering. It was not established that an additional ischemic insult in the 30 minutes prior to delivery was causative of the injury. Now, the claimant then appealed to the Court of Appeal, and in a very detailed judgment, Lord Justice Jackson went through manifold criticisms made by the claimant of the defendant's expert evidence and the way that Mr. Justice Goss had approached that. That includes, interestingly, the application for additional evidence to be relied upon in the form of evidence that one of the defendant's doctors was guilty of misuse of cocaine 2 months after the trial. Lord Justice Jackson wasn't persuaded of the relevance of this new evidence. In any event, the Court of Appeal determined that the function of the trial judge is to weigh up the conflicting medical evidence and to make findings. In a case of this complexity, there would almost always be features that point in each direction. There were legitimate differences of opinion between reputable and experienced experts, but what the judge had done is to reach a logical and reasonable conclusion, and the Court of Appeal wouldn't interfere with the same. 2 further cases illustrate that difficulty with conflicting expert evidence. AB was a case of an 8.5-year-old girl, suffered right-sided hemiplegic cerebral palsy during birth. The course of her condition was a perinatal, which is just after birth, arterial ischemic stroke affecting the brain. The claimant's mother had presented to the defendant at 16 weeks with a complaint of feeling faint. Examination and tests revealed a small area of retroplacental hematoma, and she was discharged with no additional plan. Now, the claimant's case was that this had mandated senior obstetric review and consultant-led antenatal care with serial growth scans. During her birth at 42 weeks, the claimant suffered a hypoxia ischemic event that led to irreversible brain damage. The evidence is was that delivery at 38 weeks would have avoided the stroke, which was caused by a small fragment of blood clot from a calcified and gritty placenta. As the placenta ages, it becomes more prone to more susceptible to that consequence. Now, the defendant's position was straightforward. It denied that the finding of a retroplacental clot at 16 weeks was a significant finding. It's very common in the early weeks of pregnancy. A small hematoma without vaginal bleeding does not indicate, let alone mandate, senior obstetric review. The 20-week scan would spot the continued presence or enlargement of the hematoma, and at 20 weeks the hematoma had resolved, so there was no abnormality. The defendant also averred that the stroke was caused in the neonatal period and not pre-delivery. It was 31 hours before the claimant demonstrated any neurological abnormal signs, and the cranial ultrasound at 42 hours was apparently normal. Now, Mrs. Justice Lambert was unpersuaded that the small retroplacental clot at 16 weeks gestation mandated referral to a consultant. She accepted the defendant's evidence that in the absence of vaginal bleeding, this was a clinically innocuous finding, required no special or enhanced care. It could not, as maintained, be managed in the same way as a bleed later in pregnancy. Claimant's case on causation then was that the embolus for the stroke was likely to have been placental delivery, and that early placental debris and early delivery would have avoided the same. The learned judge found that was possible, but equally the stroke could have been caused by a range of other factors at neonatal stage. None of those other factors would arise from alleged negligence. Applying the Wiltshire v Essex Area Health Authority view on causation, the claimant must therefore fail. So the claimant failed on breach of duty and then obviously in terms of causation. Now, PXW was a case where the claimant suffered cerebral palsy as a result of a hypoxic ischemic brain injury. The claimant's mother had attended the defendant's maternity unit at 39 weeks at about 5 to 6. Observation and fetal heart rate were normal, and she was sent home. She then attended at about 9 o'clock when the claimant was born. The claimant suffered fetal bradycardia as a result of a severe cord compression. The claimant suffered acute profound hypoxic ischemic insult. Now, the case was that it was an inappropriate and negligent act of the midwife to send the claimant's mother home. Had she been admitted to the unit at that stage, she would have been observed with auscultation of the fetal heart, listening to the fetal heart, which would have led to abnormalities being detected, the application of a CTG monitor, a continuous tracing graph, and the detection of non-damaging hypoxia second to intermittent compression of the cord. So essentially the compression of the cord would have been caught at an early stage prior to the injury being sustained. The defendant's case was that the mother was in the latent first stage of labour. The application of the NICE guidelines were to encourage such women to remain or return home. The defendant further alleged that if she'd remained in the unit whilst auscultation would have been commenced, no abnormalities would have been detected, meaning no CTG would have been commenced, and the claimant would have been born in the same time, in the same manner that he was. Now, His Honour Judge Martin McKenna found that the midwife's clinical judgment was that the mother was in the latent phase of labour, and therefore the advice that she gave was in line with NICE guidance and in line with the local guidance applied by that hospital. This was a low-risk pregnancy. It would be contrary to public policy for the court to find that it was negligent not to admit women to hospital who did not require hospital admission. The judge also then went on to find that cord compression would have been intermittent and non-damaging to begin with, and it would not have been identified by intermittent auscultation. He found that what then occurred was an isolated, acute, profound insult at the end of labour, preceded by intermittent cord compression in the moments leading up to total acute hypoxia, and that further monitoring would not have identified the same. So again, another situation where the finding of breach of duty goes against the claimant, and the finding of causation then goes against the claimant and wraps matters up. The final case of NKX is a very recent case in April of 2020. It's a case of VBAC, vaginal birth after cesarean, and which, as I've indicated, increases the risk of a uterine rupture. Now, the mother in that case was adequately warned about the risks, and she was adequately counselled of the need and the difference between continuing fetal monitoring and intermittent auscultation. She understood the difference between those, and the birth plan initially was for attendance at hospital and a birthing pool with a continuous monitoring by way of a wireless device. Now, what happened is when the claimant, when the claimant's mother attended hospital, it was a busy time. There was no repeat of those warnings to the claimant. There was no repeat of the explanations as to the difficulties with a VBAC and the need for monitoring. The claimant, there was no wireless monitoring available within the birthing pool, so the claimant gave birth in a birthing pool with intermittent auscultation rather than continuous monitoring. She suffered a uterine rupture, which caused a hypoxic, acute hypoxic event, leading to major brain damage to the claimant. Her case succeeded on the basis that when she attended, even though she had previously understood the differences between the relative methods of monitoring, and even though she'd understood the risks of a vaginal birth after cesarean, those risks should have been repeated at the point that she attended hospital. Everything should have been explained again to allow her to make an informed decision, and that wasn't done. So the finding was a breach of duty. The court found that had that option been given to the claimant, she would likely have chosen to have continuing fetal monitoring, even if that meant that the baby wasn't born within a birthing pool. The claimant also succeeded on the secondary part of the claim, which is that more regular intermittent auscultation was required, and that had that occurred, the problems would have been identified about 30 minutes before they were, which again indicates how the timelines are very constrained, and the time consequences are so urgent. Had that occurred, had the claimant then, had the claimant's mother, the problems been identified 30 minutes earlier, then the claimant would have suffered mild but not severe brain damage. So causation of a significant part of the injury was established. Now, just speeding things up a little bit because of the time, expert evidence, obviously with the right team of experts, a coherent, consistent case can be carefully built. Where you've got experts who are inexperienced in their field, or perhaps lack rigor in the way that they produce their reports, or where there are conflicting interpretation of records or procedures between your experts, then it's very easy to get into a difficult tangle. Sometimes those problems have to be embraced. You have to deal with them. The onset of lockdown has led to a number of Zoom conferences where it's quite nice to be able to see the experts as you're discussing the issues between them, but they're all far enough apart that there's no fisticuffs in the way that one sometimes proceeds with a live conference. But the point that's being made really is that there are cases where you have to embrace that the conflict between your experts, but in reality you would hope, if the experts are properly instructed, if the experts are looking at the requisite documents, that your own expert evidence is consistent before you then get to present that to the other side. Obviously, there's a list there of most of the relevant experts in cases of this sort. Obviously, a midwife is a nurse specialising in the care and support of pregnant women. Most deliveries of childbirth are dealt with by midwives without the input of a doctor. And that's something that is sometimes lost because we look at the complicated cases where there have been doctor involvement, whereas in fact most of the cases of childbirth are dealt with by midwives. Obstetrics and fetal-maternal medicine is the specialism of pregnant women. They're usually called when there is a problem, or sometimes there is obstetric consultant care in mothers where there's an increased risk of problems developing. Neonatology is a subspeciality of paediatrics involving the care and support of newborn children, particularly those who are born unwell. So frequently, if the issue is that the child would have been born unwell and then there are things that could or might have been done in order to address that, then that falls in the domain of neonatologists. Pediatric neurology, and obviously a neurologist who specialises in children are essential to consider the extent of the brain injury and to diagnose and to address that. Neurorehabilitation is increasingly important because neurorehabilitation experts tend to know more about the long-term prospects of somebody suffering from a brain injury, because they deal with the follow-up beyond hospital discharge. So frequently they're more experienced in terms of how individuals will cope within the community, within their life beyond. What will they be able to do? What won't they be able to do? What assistance are they going to need? What sort of restrictions are going to be, are they going to labour under? So neuro-rehabilitation experts who are often used in spinal cases, often used in brain injury cases, can be very helpful in childbirth cases, in the right case, depending obviously on the age of the claimant and where you are. If liability is admitted, then often you're looking at rehabilitation. Very often a defendant is if the liability is resolved, very often defendants are very keen to involve rehabilitation. The general evidence is that brain injuries will not get better after about 2 years. 2 to 3 years certainly is the plateau. That's different for children because obviously the brain is developing. So there's an increased period of time when rehabilitation may be beneficial. And again, without the risk of stating the obvious, the more improvement a claimant makes may mean that the value of the claim declines. Paradoxically, it can sometimes mean that the claim increases, but it tends to mean that there'll be a reduction in the value of the claim. So defendants are often keen to involve themselves in a rehabilitative process. In terms of other experts then, neuroradiologists can be important depending on the nature of the brain injury. Frequently, a neuroradiologist will be able to identify how long the hypoxic ischemic insult is likely to have taken place. Where you're dealing with very constricted timelines, that information can be very important in terms of establishing causation. There is a standard. I'm always slightly wary with discussing standard, but the evidence in a number of cases that I've seen seems to suggest that a child can withstand about 10 minutes of hypoxic insult without adverse consequence. After 20 minutes, it tends to result in a fatality, and then between 10 and 20 minutes, you've got a linear sliding scale of damage that is caused. Obviously, the damage increases throughout that period. So that's the sort of information that a neuroradiologist may be able to identify the time period of the hypoxic insult, which can lead to obviously the pediatric neurologist addressing causation of injury. Neuropsychologists obviously are important in terms of identifying cognitive or executive impairment. Their reports, again, it tends to be with children who have got a little bit older, but their reports will put you in a good position in terms of understanding the nature of the executive problems that the claimant may have, where they're likely to get to educationally, what work they might be involved in, things of those sorts. So neuropsychologists, obviously, very important. Neuropsychiatrists, again, there's often a delicate crossover between those two disciplines, and sometimes they're in conflict, and that makes your job harder, and you wish you didn't have both experts. I think, again, it will depend upon the particular case. Perhaps neuropsychiatrists are less relevant with children, but that will all depend on the nature of the presentation. Obviously, what they will deal with is the interface between organic brain disorder and psychiatric disorders. The line between those is frequently drawn more clearly by lawyers than it is by the doctors treating and diagnosing. It very much is a grey area, but there are certain cases where obviously you will need a neuropsychologist and a neuropsychiatrist. Try and avoid it if you can. That's just my personal view, but obviously there will be some cases where you can't. Other evidence, obviously, care and occupational therapy. In most cases, you'll get a single report that deals with care and OT. Most good care experts are able to deal with those issues. Therapy experts, again, usually you will not need an expert's report, a Part 35 expert's report from each therapist. And normally that you will have evidence from the care and occupational therapist and perhaps the case manager in terms of what the claimant has been doing. And then you'll have a cost of that from the treating clinician. There are cases where if it's a very substantial part of the case where you may need an expert report that deals specifically with the need, for example, of physiotherapy, long-term physiotherapy, costs of physiotherapy and the like. Those sorts of reports are sometimes necessary on a case-by-case basis. Speech and language therapy is often very relevant. And sometimes with physiotherapy, you may have a situation where hydropool is very beneficial. So you may have the crossover between the physiotherapist saying that this is what should be provided, and then you obviously need your accommodation expert to address the likely costs of doing that. Just in relation to accommodation, obviously at the moment, the case of Swift and Carpenter was in the Court of Appeal 2 or 3 weeks ago. We don't know what the answer to that is going to be. Keep your eyes peeled. Obviously, that's very important in terms of most of these cases will involve a need for special accommodation that is very often a bungalow that has got especially depth-wide doors. There may be equipment that needs to be fitted in. You may have the obligation to provide extra space for carers to stay overnight. All of those factors, and they lead to an increased cost. How that is then determined in the light of the negative discount rate, we'll see what Swift and Carpenter say about that. The only other thing that's not on the handout is in relation to capacity. Very important to get, if a claimant hasn't got capacity, then they're going to have the obligations of usually of a professional deputy. In big cases, the court is very, very wary of having a family member as the deputy. It's almost invariably better to have a professional deputy. That involves significant expense, and a report is usually obtained. You can do the calculations for facts and figures, but it becomes a little bit difficult, and the court in big claims normally prefers to have evidence from somebody who provides those professional deputy services and will set out the likely costs for a lifetime. Yes. Finally, just in relation to children generally, you've obviously got a situation where brain injuries, the frontal lobes, the development of children is more complicated, and it takes a longer time to determine where the end point is. So the timing of the settlement will be informed by medical experts. Such experts, whether it's the neurologist, the neuropsychologist, or neuropsychiatrist, should have pediatric expertise, so they should be comfortable with where the claimant is likely to reach their end point. And obviously that's slightly different from adult claimants. Obviously, because you've got that situation where the trauma was so many years ago, you've got fading memories in terms of liability. Although you may have a situation where a lot of what is being determined is by reference to medical records, you may also have factual determinations about what was said at various times and what was said to the mother, for example. So very often it's appropriate to have a split trial and to get liability determined. And obviously then consider quantum at a later stage. Again, one of the issues with protective families is simply this, that if you're asking for a significant professional care regime, ideally you'd want that regime in place before you actually get to the hearing, so that the court can look at what is taking place, and if it's working, you can work on the safe assumption that it's likely to continue in future. That's sometimes difficult where you've got children, because you've got protective families who are doing everything. Again, one understands that, and it doesn't necessarily mean that you can't claim for a professional care regime, but if the likelihood is that that's going to continue, that obviously impacts upon how the court assesses that. So that's something that one needs to look at. You need to take the family out of the immediate situation of how they're dealing with it now, and ask them to consider the long-term repercussions, as obviously the claimant becomes older and the family will become older, and the situation changes. So far as education is concerned, again, children with brain injuries usually struggle. So you may it may be sensible to get some sort of evidence in relation to the school, from how the claimant is doing, and just to get an idea of where they are. Capacity I touched upon in the previous slide. Again, it's too broad a subject to deal with now in terms of what amounts to capacity, but there are two elements. There's the capacity to litigate, but there's also the financial capacity in terms of looking after the long-term interests and the need for the court of protection, which is why the costs of a professional deputy are always so significant. Now, finally, just we're very, very short of time. JR Protected Party is a case worth looking at as a very useful quantum checklist. I won't go through it now, bearing in mind that time, but what happened is that there were a number of quantum issues that were in dispute. So Mr. Justice William Davis gave judgment in relation to those issues, and in doing so went through all of the elements that were either agreed or were in dispute. So it's a very, very useful checklist on a claimant who suffered very significant cerebral palsy. Again, for example, you've got general damages, I think, were in the region of, I think, about £300,000, weren't they? Yes, life expectancy was to 70. General damages are agreed at £300,000, very much at the top of the bracket. Future loss of earnings, of course, you were looking at what the claimant's siblings and cousins did in order to determine what the claimant was likely to have done. Obviously, what the parents did as well, but it's a speculative exercise, but that's the sort of evidence that goes to those issues. No award was made under the Robertson Johnson heading for accommodation because, of course, the negative discount rate, which now falls into the Swain case, that we're waiting for the result, but there were various things that were awarded, such as a multi-powered wheelchair, intensive physiotherapy regime. No award in respect of a hydrotherapy pool, but an award was made in respect of attending a local hydrotherapy pool, so about £2,000 a year was awarded as a cost of that. I won't go through everything. It's worth looking at because it's a pretty good checklist, really, as to all of the elements that fall into these serious cases in terms of quantum. Now, just as an end point then, I'm just going to see whether there are any questions that anyone wants to ask. Nothing's come through at the moment. Well, as I said, if there are any questions anybody wants to raise, please feel free to send an email. And if I could just thank everybody for attending and taking the time to listen. If anyone's got any observations, please feel free to email. I'm very happy to deal with responses in that way, or any recommendations in terms of how these webinars do or don't work. Gloves are off, please say. Next week, the Tuesday webinar relates to credit hire. I'm asked to indicate how interesting that will be. I'm sure that if anyone is going to make credit hire interesting, I guarantee Farrars are going to try to do that. But thank you everybody for attending.